by getting ahead of issues and making sure that you all are up to date. This is, I will tell you, my favorite topic. I haven't done this topic for you all, I think in a few years, but I did, I think pre-pandemic, so maybe 5 or 6 years ago, I did this topic, and I'm back doing it again, and it is my favorite. It's my favorite because I think next to maybe PAGA and wage and hour class claims, these are the most prevalent claims in California. And that's because they're really hard to navigate. There's a ton of laws that intersect, and they're constantly changing. As you know, every time you turn around, we've got new regulations and a new change, a new leave law even. So it's constantly changing, which makes it really hard for employers to stay on top of. Normally, when I teach leave and accommodation, I do it in a 2-day course over 16 hours, 8 hours each day. I'm going to compact all that into 1 hour for you. It's a lot, but I think we can do it. It does mean that I'm not going to hit some of the finer points, like what a serious health condition is, or the key employee exception. But if you have those types of questions that aren't answered, please feel free to reach out to me, or I will stay on afterwards, and you're welcome to ask me questions too. In fact, my email address is on the screen. That's the general phone number, but if you change those last 2 digits, the 00 to 16, that's my direct line, and you're welcome to call me as well. Okay. So when I said that there was a whole host of laws that intersect, I wasn't kidding. I put them up here on the screen for you. It's a bit of alphabet soup when you're talking about leave and accommodation. And I think that people, they mostly, when they think about leave, they mostly think about the first 2, right? FMLA, CFRA, because those are kind of your biggies, but it's only part of the puzzle. And you really can't see the entire puzzle unless you're looking at them all, because they do interact. Today, we're going to focus on the biggies. So we're going to focus on these first 2, which I lumped together, FMLA, CFRA. We're going to focus on PDL, pregnancy leave. Then we're going to focus on these next 2 together, FEHA and the ADA. Those are our accommodation statutes. I'm going to touch on bereavement and sick leave as well. Okay. So let me give you a little bit of our roadmap today. I'm going to go through kind of the nuts and bolts that you need to know of the newest changes in the law with respect to the FMLA and the CFRA, then the ADA and FEHA, and then PDL, and that other is sick and bereavement. I'm going to touch on sick and bereavement because those are both have new changes. Then I'm going to pull them all together, and we're going to track 2 cases, one of which is the most complicated scenario you can get, right? It is your pregnant female who has a high-risk pregnancy and later has postpartum, and all the laws intersect. If you can follow and track that leave with me, you can track any leave. That's my promise to you. So we're going to pull it all together. We're going to track 2 scenarios, one pregnancy, one non-pregnancy. And then I'm going to go into what I think everybody's dealing with post-pandemic, especially this year, and that is remote work and mental health. Those are probably the hottest 2 topics when it comes to leave and accommodation right now. Nobody wants to come back to the office. There are doctor's notes flying in that say, you know, my patient needs remote work. How do you handle that? It's really tricky. And then mental health too, right? So we're going to talk about those in a little bit more depth because they are so hot and what I see employers dealing with the most. And then I'm going to end with kind of my top 10 practical takeaways. That's what we're going to do. So let's start with FMLA. These are your basics updated to the most recent changes in the law, right? So if you think back to the laundry list of leave and accommodation statutes, they each have a piece of that puzzle. The piece that FMLA and CFRA has is the leave piece, the actual leave piece, right? And that leave is unpaid. It's 12 weeks or 26 weeks, depending on what the reasoning is. Okay. And it's non-work time, right? The employee has an absolute right. If they qualify, they have an absolute right to that leave period. They have to come back to the same job, right? You have to maintain their benefits. I envision FMLA and CFRA as this frozen piece of time. you act almost as though it doesn't exist. So the person is no better off and no worse off when they come back from that leave. They basically stop their employment, it freezes, they pick right back up when they come back, in terms of seniority, in terms of everything else, right? They have to return the same or equivalent position. Equivalent means virtually identical. I see employers get in trouble when they try to bring them back to a different shift, or what happens a lot is the person's on leave and you realize they weren't very good at their job. And so now you want to bring them back to a slightly different role because somebody else, it turns out, is better at their job duties. You can't, right? They have to come back to that same job and the same seniority. It is unpaid unless there's some PTO, vacation, or sick time, and you do have to maintain benefits, okay? Eligibility. The other statutes don't have eligibility requirements. We're going to talk about that, but FMLA and CFRA does, okay? So it's 12 months and 1,250 hours. That 12 months means 12 months total. It doesn't have to be consecutive. Does anybody know how far back you look for 12 months? I'll give a gold star if anybody knows. Okay, I'm not seeing it. 7 years. You look back 7 years. Okay. If they've worked for you for 12 months at all within the last 7 years, then they fulfill this requirement, right? And 1,250 hours, that is consecutive, right? So that is the exact kind of preceding time period. They have to have worked that 1,250 hours, and that's only the hours worked. Whereas the 12 months is the months employed, even if they were on leave, even if they were on vacation. But that 1,250 hours is actual work. Okay. All right. So there are these 5 qualified requests that you can see on the screen. They can take the leave for their own serious health condition, for the serious health condition of a family member under the CFRA that now includes a designated person. Okay. Nobody knows what designated person means. It's relatively new. The statute says that it's any individual related by blood or whose association with the employee is the equivalent of a family relationship. Beyond that, we have no guidance into who a designated person is. And they're allowed to designate 1 per leave year, essentially. The third is for the placement of a child for adoption or foster care. 4 is your covered service member, to care for a covered service member. This isn't just family member, it's broader. It includes next of kin. And then 5th, the exigent circumstances military leave. So somebody's called to duty and they need to make arrangements for that. Now, what's important is these last 2 are FMLA only, right? So not CFRA. So we're going to talk about how that, what that means, but essentially this is one of those scenarios where the FMLA will run, but the CFRA will not. So employees can essentially double dip, right? They can take the 12 weeks or 26 weeks for the military leave, and they still have 12 weeks of CFRA left that they can take for the adoption or foster care or for a designated person. So that gets a little tricky there. All right. I've collapsed into 2 slides, your obligations and the employee's obligations. So these are yours, and you can see there's quite a lot of them. The easy ones, your postings in your break room, your handbook or your policy, and then there are the ones that are triggered and have rather specific timing requests or timing requirements, your eligibility notice, your rights and responsibility notice, your designation notice, which some employers collapse into one. But you have very specific timeframes in which you have to get those out. And I see this violation all the time because what happens is you'll have an employee who goes to their supervisor and says, oh, by the way, I'm getting surgery next month. I need a day of vacation, right? Or I need a week of vacation. And the supervisor submits a vacation request, not telling HR that it's because of a surgery, it's because of some medical issue, and that the FMLA may be triggered. And now you, as the employer, have violated the employee's rights, right? So these requirements are pretty hyper technical, but they're strict and they're important. Okay. It also provides for intermittent leave. That doesn't mean 12 weeks all at the same time. The intermittent leave must be medically necessary. You can temporarily transfer somebody during it as long as they come back to their same position. And that transfer is justified by the doctor's note. This does not mean unscheduled and unpredictable absences are okay. And I see that a lot where somebody's on FMLA leave, intermittent, and suddenly their intermittent leave time is, half days every Friday, or suddenly the Monday following a holiday, right? And that's not the way that this is supposed to work. Okay. CFRA versus FMLA, the differences. Okay, so this is kind of a short little cheat sheet of the few differences between the two. They're about 98% the same, but those differences are important. So CFRA covers registered domestic partner and has a broader family member definition, including parent-in-law, grandparent, grandchild, sibling. It also covers that designated person that we talked about. Okay, so those are situations where your CFRA would run and your FMLA would not, and your employee may be able to kind of double dip. CFRA covers employers with 5 or more employees now, right? That's relatively new over the last couple of years. Whereas FMLA covers employers with 50 employees within a 75-mile radius. There is no radius. There's no 75-mile radius for CFRA anymore. CFRA does not cover pregnancy. That's because in California, we have our own statute, PDL, right? Which we'll talk about. FMLA covers the military service leaves, right? There are differences in the medical certification. CFRA requires stricter privacy considerations, like you can't ask what the diagnosis is, okay? Meaning those FMLA forms that you can pull off of the DOL or the government website, you can't use those in California because they ask information like what the diagnosis is. Okay? If you have been using those forms and you need California forms, you're welcome to reach out. CFRA doesn't allow second and third medical exams for family members like the FMLA does, and the bonding leave is different. For FMLA, you can require that they take it in one increment, and CFRA, you can require that they take it in increments of 2 weeks with 2 exceptions, which I always thought was the weirdest part of the law. But nonetheless, that's what it says. CFRA, these are most recent changes in the last couple of years. It used to be that you could force parents at the same company to split the 12 weeks. You can't do that anymore. And there's no key employee exception under the CFRA anymore either. So you can see kind of a few differences, mostly the same, but really important differences. All right. I'm going to move to ADA and FEHA, but before I do that, Jenny, do we have any FMLA CFRA questions?
The questions we've had are, so Adela De La Cruz asked, how does intermittent leave work here if the employee must not work at all?
So it depends. I hate to say that because it's such a lawyer answer, but it depends on what we're talking about. So it's going to be dictated by the doctor's note. So if they can't work at all, does that mean they can only work 2 days a week? They can't work at all on those other 3 days? Or that they can't work beyond 6 hours a day? Or what does that mean? Normally, that's what you're talking about when you're talking about intermittent leave. You're talking about they can only work certain hours in a day or certain days a week, or they need, every 3rd week off for therapy or whatever it is, right? If they can't work at all, then that leave is going to run concurrently. It's not going to be intermittent. Okay. Can we find this material in the employers group website? I see. If you mean the slides, they will be available. And then I see one more. The question is, upon returning employee to work in a union environment, and there is only one position, such as a room attendant, and position was eliminated during the leave, what are we obligated to do? Okay, it's very specific. So I'm reading that this is actually happening in your organization or has happened in your organization. One of the exceptions to returning somebody for leave is if they were laid off as part of a mass layoff, reduction in force, something like that. That is one of the exceptions, right? They are no better off and no worse off because of the leave. So if they would have been slotted for layoff without the leave, then they're still slotted for layoff with the leave. You're just going to be really careful to dot your I's and cross your T's so that you can show that that person was selected for layoff, not because they were on leave, right? Hopefully you're choosing those folks based on tenure or some objective reason that makes it very clear that they should have been selected. Okay. All right. Let's go. I see a couple more coming in. I'm going to pause there so that we can keep on track, but I'll keep coming back to your questions here. Okay, so let's switch gears a little bit, talk ADA FEHA. Okay, ADA and FEHA, meaning the Americans with Disabilities Act, and California's version of that, which is the Fair Employment and Housing Act. Those are our accommodation statutes. Okay, they're similar, but there are some pretty key differences. So if you, as an HR professional, have been administering leave and accommodations for any given time, you will be familiar with this statement, which is that what the ADA and FEHA require is employers to accommodate qualified individuals with disabilities unless it poses an undue hardship. Those are kind of your three buzzwords, right? Accommodation, disability, undue hardship. Okay. So who is disabled? That's the very first question, right? Officially, it's an individual with a physical or mental impairment who, with or without reasonable accommodation, can perform the essential functions of the job that he or she holds or desires. It's a bit of a mouthful. Unofficially, it's just about everybody, honestly, right? And the law is designed that way. In fact, when they amended the ADA with the ADAAA several years ago, it was because of this very reason. Employees were stuck in a bit of a catch-22. They were either too disabled to perform the essential functions of the job or not disabled enough to be accommodated, right? So if you read that history, the very purpose of the ADAAA was to get employers to skip over the question of whether or not an employee was disabled and go straight to how can I help? That was the purpose of the law, right? And it was very effective. Essentially, a disability is anything that impacts a major life activity. And here are some major life activities, right? You can see how many they are. And I'll give you an example that kind of hits the point home. And that is, you see seeing is on there. Seeing is a major life activity. I wear contact lenses, right? So my ability to see is limited. Am I disabled? Right? Under the law, I would be. That's how broad it is, except for the law specifically carves out corrective lenses. And it specifically carves out corrective lenses because otherwise it's so broad that I would be included. I'd be considered disabled, right? So I kind of jokingly say everybody, but really it's almost everybody. There are a few that are in influx, obesity being one of them. There's a split across the country as to whether obesity counts as a disability. I fought this battle in the courts in California and got a ruling that it was not a disability, but that's not true everywhere. So be careful with that one. So flipping to what is an accommodation? Accommodations can really be almost anything. And the law is very clear that it can mean additional leave beyond the FMLA and CFRA, beyond the 12 weeks. It's probably the classic mistake that I see from most employers is they get through FMLA or CFRA through the 12 weeks and they think they're done and that they can go ahead and terminate, but you can't because you have a duty to accommodate additional leave beyond that 12 weeks unless and until it's an undue hardship. Right. But it can include far more than just leave as well. And it's a tough standard, right? So undue hardship is not very well defined in the law. Most courts look at it in terms of financial cost. For example, if the accommodation is a power jack that helps somebody lift 50 pounds and that power jack costs $25,000, okay? That's probably not a reasonable accommodation for an employer of 5, right? But it probably is for McDonald's, right? So that's generally how the courts have looked at it. I tell my employers, when you're evaluating whether or not something's an undue hardship, ask yourself, is it crushing to the business, right? That's generally how high the standard is. Is it crushing to the business for me to allow this person 4 more weeks of leave after FMLA is done? Probably not, especially since leave is unpaid, right? which makes it difficult to figure out when is enough enough. When can I end this person's leave? When can I part ways, right? Because that's the standard you're dealing with is it crushing to the business for me to accommodate? Okay. All right. There are a few things where courts have said these are not reasonable. You don't have to provide them. Okay. If it's not on this list, you got to consider it. Eliminating essential functions. And that means permanently. You may have to eliminate functions for a time period, right? But not permanently. Providing a stress-free work environment, right? Of course, wouldn't we all love that? Providing a new supervisor, an indefinite leave of absence, rescinding discipline, right? Now, if somebody has if somebody's symptoms from their disability impacts performance, like somebody has narcolepsy and so they're caught sleeping on the job, and you know about the narcolepsy, you can't discipline them for that because it stems from the disability. But if you discipline them before you knew, you don't have to rescind it. Okay, you just can't do it anymore. And lowering production standards. Again, you may have to do that for a temporary period of time. If you have a salesperson who has to sell 10 units, and they're only able to sell 7 for the next 6 weeks, that could be a reasonable accommodation. But lowering it to 7 indefinitely is not reasonable. Okay. The other thing the ADA and FEHA requires is that you engage in the interactive process with the employee to find an accommodation, right? It's a two-way street. Okay. I put up here kind of a short synopsis of it, right? But essentially what you do is you sit down with the employee, you talk through the key portions of their job, you talk through what their medical limitations are, and you work together to find an accommodation. And it's an accommodation that works for both the employer and the employee. In today's world, employees are really bold, right? They're demanding certain accommodations. I want to work from home permanently. Right? It's my right. I need an accommodation. I need you to let me to work from home permanently. That's not the way the law works, right? It's a two-way street. It's a dialogue between both of you, and they don't necessarily get the accommodation they want, right? As long as they're accommodated. All right. A quick word about essential functions, and then I'll pause so we can answer some questions. So the other key question before we kind of leave ADA FEHA land is, what is an essential function of the job? I see this confused a lot too. So for example, my job is to defend employers and to keep you all safe, right? That's my job. The fact that I present at events like this is not why my job exists. That's not an essential function. It's a marginal function, something I do because it benefits employers, but it's not why my job exists, right? And when you look to see if something's an essential function, can they, sell 10 units? Do they need to show up at work? Whatever those functions are, you're going to look at the job description. You're going to look at what other employees in the position do to figure out if it's really essential. And you all are the stopgap. Right? You'll have managers that tell you this duty is essential. They can't perform it. They need to go. Right? But it isn't always. Right? I had a case where it was a car dealership, and an employee had a seizure disorder and could no longer drive the cars. And the job was to ferry the cars from the lot to another location, wash and detail them, and bring them back. And the employee could no longer drive because of the seizures. And the manager said driving is an essential function of the job, and they terminated the employee for it. But in the case, we determined that all these employees were minimum wage workers, and easily somebody could have driven the cars back and forth while that employee stayed washing, right? It wasn't essential. And making that accommodation was not an undue hardship. Right? So you kind of have to push back and make sure that you're thinking critically about it. And the case law is really generous. Here's the case I put up on the screen of somebody who had obsessive compulsive disorder and couldn't show up to the job or would show up late, and was fired under the idea that attendance was an essential function. And the court said, not necessarily. Right? That's how broad the law can be. So be careful there. All right, Ginny, I'll pause for a second before I move on to PDL. I know I'm going fast.
We have,
Take a few questions.
yeah, we have quite a few. So Melissa Perez was saying, what if the employee's doctor requests remote work, but we don't have any remote workers?
I'm going to talk a lot more about remote work in a minute. But I will say, if the fact that you don't have anybody who's remote, or the fact that you've never done it before is not enough. Okay. The question is, can it be done? Right? Is it an essential function of the job that they be in person? There's cases where employers have been hit because their reasoning was, well, we don't do remote work. We've never done remote work. It's something that we've never done before. The question really is, can you, right? Or is it an undue hardship? Right. Maybe I'll take one or two more and then we'll keep going.
Sure. Sombra was saying, confirming in California, we should only be using the CFRA certification of healthcare provider form and not the WH-380 form.
So you don't want to use the federal forms, okay? Which means you can use, the state does put out CFRA forms that also comply with the FMLA, or you can get them from organizations like the chamber or from me, from our firm. But yes, you need forms that comply with both. You can't use the federal forms. Or if you're going to use federal forms, you got to black out the parts that don't comply, like the questions about diagnosis, which you can't ask in California.
Okay. And one more, or?
Yeah.
Okay, Sharon has asked, so in terms of ADA, reasonable accommodation, what if they've exhausted the 12 weeks of FMLA and it'll be months more? What do they do, and do they have to carry insurance? What does the business have to do? Do they have to carry insurance?
Good question. So in terms of the benefits, once the FMLA and CFRA is exhausted, you're no longer required to maintain the benefits like you are under the FMLA and CFRA. You are required to give at least 15 days notice. So you could, if you wanted to, cancel benefits, after that point in time. In fact, your policy may require that you do. That's a question you should really ask your broker first to find out what your plan requires. Some plans will maintain for 17 weeks because of PDL. Some plans will maintain through 12. So I check with your broker first, but in terms of benefits, the law does change once FMLA and CFRA is exhausted, and you don't have that same obligation anymore. Yeah. All right. We'll pause there and keep going, but I'll keep answering questions as we go. All right, so to wrap up our basics here, PDL. PDL is specific to California, although federal law also has its own pregnancy protections. So PDL applies to 5 or more employers with 5 or more employees, and they're entitled up to 17 1/3 weeks. It's not for just being pregnant, right? A lot of employees think that. They think, I'm pregnant, I get 4 months off. It doesn't work that way. It's for disabilities associated with the pregnancy. And that's really broad. It includes things like morning sickness, prenatal care, even post-pregnancy, like postpartum, but it is not for simply bonding, right? And there's often an education piece that has to happen there with employees. You also have to temporarily transfer the employee if it's medically advisable or reasonable. You can't require it. I had an employer one time who had a pregnant employee working in the manufacturing line around chemicals and was concerned about her and her baby, and so transferred her against her wishes. You can't do that, right? You're not her dad or her mom, right? You're her employer, and she gets to make that choice unless it's medically advisable. They must be reinstated to the same or under very limited circumstances, a comparable position. This is stricter than the FMLA CFRA. It is, they truly must come back to their same job unless there's a plant closing or a mass layoff. Okay. You have to maintain benefits as well under PDL. So if you stack together PDL and the CFRA, you get a total of potential 7 months of benefits that are protected. It can also mean intermittent leave, and it also means all the accommodations under the ADA and FEHA, right? So any accommodation that you would offer to another disabled person, you may also have to offer to your pregnant employees if it's medically necessary. and they're eligible as of the date of hire, which can be really frustrating to employers, right? To hire somebody and find out a week later that they're pregnant, they're going to be gone in a couple months. But nonetheless, that's the law, right? We're going to talk about tracking PDL in a minute. Okay, before we move on, I wanted to quickly mention sick and bereavement. Sick leave has been one of the most difficult areas for employers to grapple with in the last few years. And that's because it's changed several times. And there's so many cities and municipalities now that have their own, from San Francisco to Sunnyvale to Santa Monica to San Diego to you name it. And not just California, all throughout the country, states and municipalities have their own sick leave laws, and they don't jive, right? They're all a little bit different. And so it's hard to develop that policy that's fully compliant. So make sure you know where you are, you've had counsel look at it, and you've got a sick leave policy that is current and addresses wherever your employers are or employees are. As of January 1, 2024, California's is expanded to 5 days from 3 days. You're probably have already heard this. You probably know it's coming. You're probably updating your policy, but I wanted to put it here just in case. It also includes a sick leave for themselves, a family member, and that designated person, which doesn't have the same definition as the CFRA. So we don't really know what designated person is. And don't forget, it has a retaliation part. So you can't in any way deter somebody from taking their sick leave, including asking for a doctor's note, right? You can't ask for a doctor's note until after those sick leave days. Bereavement, as of last year, we also have a new bereavement leave. It's 5 days unpaid, but they can use PTO vacation sick. They don't need to be consecutive, but they do need to be within 3 months of the death. And I put up there the different family members that it applies to. You probably have updated your handbook to include bereavement leave. If not, you're going to want to make sure that you do. Okay. So to wrap up our basic section, I made you a chart. I love a chart. It's my type A personality. I put FMLA CFRA in the one column. I put ADA FEHA in the second and PDL in the third. So you can kind of in one slide see the differences between them, right? So you've got FMLA CFRA has eligibility requirements. ADA FEHA does not, and neither does PDL. FMLA CFRA is 12 to 26 weeks. ADA is no set amount versus PDL, which is 17 and a third. So you can see kind of every kind of key category. I've built you this chart so you can kind of use it as a quick reference guide. It's another reason why you're probably going to want the slides, just to make it easy in one space for you. Right. Okay, we're going to do some tracking. And we're okay on time. Jenny, if there are a couple of questions, I can take a couple
There
questions.
are definitely some questions.
Okay.
So going back to Jonathan Rodriguez, he said, we give an employee 30 days of ADA once they run out of their 12 weeks of FMLA CFRA. Do you think that's fine? If we're not able to accommodate their restrictions, can we let them go after 30 days?
Okay. There were kind of two parts to that. So the first part is the 30-day part as a blanket policy. So the EEOC has come out, and several employers have been hit for this, of having a standard rule. So after 1 year of leave or after 6 months of leave, you terminate, right? You cannot do that. Okay. So if you're talking about a blanket, we give 30 more days and then we terminate, I would change your policy. There's big risk there. Okay. It has to be a case-by-case analysis. What I would do as kind of best practices is once you get through those 12 weeks, I would send that first letter that says, we're not terminating you. We're happy to accommodate, this next 4 weeks that you need, or 3 weeks or whatever. However, you need to know that your leave is no longer job protected. We can't do it forever. It's a hardship on the business, and we may have to fill your job, right, at some point. And then you get through that next, 30 days, 4 weeks, whatever it is, and you send your next letter that says, all right, at this point, we're not terminating you, but we are going to have to go ahead and fill your job, right? Or we may, or whatnot. And then you let that next period go by and you send your third letter that says, okay, you're still not back. At this point, we have to part ways, or whatever, however aggressive you're willing to be. I have some employers who just keep them on the books forever, potentially, right? Because there are employers who've been sued after a year, after terminating after a year and a half, and still kind of lost those cases. Because if you think about it, at that point, the employee isn't being paid, they no longer have benefits, they're basically just a name on the payroll, right? So how is that an undue hardship? It's not. So depending on how aggressive you are, you can kind of do this 3-step process to where you can at least fill the job and then ultimately terminate or keep them on the books, depending on, you know, your tolerance for risk. I hope that helps. I think there was a second part to that question that I may have missed or forgotten.
So they said, can they let them go after 30 days? But
yeah, I think I answered.
Yeah, I think you
but
did.
If there's a clarification to that question, feel free to put it in the chat box. All right. Let's keep going with the tracking, and then I'll pause again.
Okay.
All right, let's track. This is my favorite part. Putting it all together. So the first one, I'm going to start with pregnancy. And if you follow through kind of each of these trackings, like I said, you'll be a pro. First one, pregnant Paige. Pregnant Paige is expected to give birth to her first child on June 1st. She's worked full-time for a company that has 100 employees in Los Angeles for the past 5 years. Paige calls the HR manager 4 months prior to her due date to let the HR manager know she's pregnant, but she intends to work up until the baby's birth. Okay. So this is what the leave looks like, right? So she works up until birth. Here's birth. Okay. She may have her sick leave still. So she may have her first couple of days of paid sick leave. She's going to have PDL. PDL only covers pregnancy related disabilities, right? So it's only going to cover the recovery time. It doesn't cover bonding. So you can see it stops after the 6-week recovery. Could be 8 weeks. Okay. FMLA, however, covers both disabilities and bonding. So it starts as well, but it keeps going. Okay. And whenever PDL stops is when CFRA for bonding starts. Hopefully this makes sense to everybody. Okay. I'm going to hold the ADA FIAT question. We'll get there. Okay. So this is your basic birth scenario. Okay, you're going to have sick, FMLA, PDL. PDL is going to stop, CFRA is going to start, and then they'll have their 12 weeks of bonding. Okay. All right. Part 2. About 1 week after giving her notice, Paige experiences complications with her pregnancy. She approaches HR and states that she will need time off to attend appointments every Friday. Remember, those appointments count for PDL, right? So what does that leave look like? It looks like this, right? She's got start, stop, start, stop. These appointments that counts as potential sick leave. It counts as FMLA. It counts as PDL. Okay. And then let's say she doesn't need them anymore. She uses the rest for the recovery period. And then once that PDL stops, she's recovered, the bonding CFRA starts. Make sense? Hopefully. I see some head nods. Okay. All right. Part 3, it gets messy. Paige has her baby on June 2nd. She recovers within 4 weeks and takes 12 weeks of bonding time with her baby. Shortly before returning, Paige sends in a doctor's note stating that she's suffering from postpartum and needs another 60 days off work. What does this look like? Okay. So remember, we have her doctor's visits in the beginning. Then we have her recovery period. She runs out of FMLA because it's only 12 weeks. And her PDL is 17 1/3 weeks. She recovers, it stops, and her bonding starts, right? She gets her 12 weeks of bonding, and then she gets postpartum. So the CFRA stops, and any remaining PDL picks back up and starts again, because that counts as a pregnancy-related disability. I know that's complicated. That makes sense? Everyone with me? Hopefully? Yeah? Okay. A little bit messier. Okay. What if Paige notifies you in the 2nd week of her bonding leave, that CFRA leave, that she's suffering from postpartum depression, needs 60 days off work? What happens to the bonding? It starts, then it stops. The PDL for the postpartum picks up. She recovers from the postpartum, it stops, and she still has the rest of her CFRA bonding. Tricky, right? Okay. Notice this a lot. That's why we're gonna want the slides. Okay, one last wrench. Assume that Paige has complications from the start of her pregnancy and was placed on bed rest during the 3rd month of her pregnancy. What does that leave look like? There's actually 2 ways this leave can look, okay? The first one looks like this. You have FMLA through the 12 weeks, you have PDL through the 17 and 1/3 weeks, and then she runs out of both. And then her bonding picks up after birth. So there's this gap here, right? What is covered by this gap? There's kind of 2 ways to look at it under the law. Some people think that you can take that CFRA and use that for the time, okay, to cover the gap. I think I use that as FEHA ADA because that is disability time. She's on bed rest. It's a disability related to pregnancy, right? So that's ADA FEHA time and she still gets her bonding. Either way, you're still covered by the exact same amount of time, but you can see she's out for a substantial amount of time. And you've got, you know, if you include sick leave, 5 different laws that are intersecting here, right? This is how it gets complicated. Okay. All right. Let's switch to non-pregnancy. It's much, much easier. Okay. Workers' comp. Chase severely injures his back February 28th while lifting boxes at a major corporation employing hundreds of employees. He immediately leaves work. His doctor determines he needs to have back surgery and then will require physical therapy before he can return to work. He'll be out for 9 weeks. What's his leave look like? You have workers' comp going. You also have FMLA going. You also have CFRA going. And that's it, right? For the full 9 weeks. Workers' comp leave isn't actually a leave statute. That's the mistake I see employers make is they will trigger the workers' comp process, but not send FMLA or CFRA paperwork, and they run together, right? And you want to send it because afterwards he'll get back from workers' comp leave and then say, oh, well, now I want 12 weeks to care for my mother, right? So you want to make sure you get that paperwork out at the same time, but you can see it's much simpler. Okay, one more. After 9 weeks, he's not ready to return. He has complications. He needs another 10 weeks, right? So what does that look like? He's out of FMLA. He's out of CFRA. This is when your accommodation leave picks up, right? Your ADA FEHA. All make sense? Hopefully. Okay. So that's non-pregnancy. You can see much, much easier. All right. I'll pause and take two questions here, Ginny.
We have quite a few, so
Yeah,
let me just make sure. Maybe we'll go to the ones that are relevant to this topic.
that's perfect. And like I said, I'll stay afterwards and we can fill in the gaps.
Yeah, so okay, I think we've answered kind of Tiffany's question about touching on the Pregnancy Workers Fairness Act and what our obligations are there. Assist on several occasions. Okay, please. Oh, sorry. Dear.
Okay.
Okay, so some of these are more like general. So how about if we never hear back from the employee on leave of absence is one of them?
Yeah, it's a great question. It happens all the time. So you send the paperwork, you never hear back. You have to err on the side of caution, right? Think about a judge or a jury 3 years later. That's how I always think of things, better or worse. And think about if that person was in the hospital and unable to communicate, right? So with that in mind, I would give them multiple chances. The FMLA requires that you give them at least one additional extension, but I would give several. I would make it very clear in the paperwork that you have followed up several times and that the process failed because of them, not you. And then after several extensions and no follow-up, I would send that communication that says, look, you're on unauthorized leave. We haven't heard from you. And we don't know if or when you're ever coming back, which makes it really hard for us to staff and operate the business, right? That's an undue hardship. Indefinite leave and not knowing if or when the person's coming back, does count as kind of an undue hardship. I just make sure that you lay the clear documentation down that shows that it's their failure, not yours, before you get there. Yeah. All right, let's keep going. And then, like I said, I'll stay at the end. Let's talk remote work and mental health. I bet if I asked you all if you've dealt with these issues, it would universally be yes and absolutely. I have one client who brought their workforce back to 3 days a week in person, 2 days still remote, and got over 400 remote work doctor's notes. Okay. And the problem with these doctor's notes is they don't say, these are the person's restrictions so that you can sit down and talk about a bunch of different accommodations. These doctor's notes just say, my patient needs remote work, right? Which isn't a restriction, that's an accommodation. They skip the restriction process, which makes it really difficult for you to engage in that process. And it really stems from the pandemic, right? The pandemic forced everybody to be remote. And so now all those jobs that previously couldn't be remote, and now everybody knows they really can be, because they were during the pandemic, right? It makes it really hard for you to argue it's an undue hardship when for the better part of 2 years, people were in fact remote, right? So it's kind of changed the landscape in terms of the interactive process and making it a lot more difficult to push back, right? And the EEOC has weighed in. The EOC has said that employees with disabilities who are being asked to return to work but want to continue to work remote work will not automatically be granted remote work as a reasonable accommodation, which is good. But they've also said that it may very well be warranted. So it leaves you in this kind of difficult spot. I would look at 2 main questions when you're grappling with these. I'm going to do some examples for you. But one, is the in-person work an essential function? Is it in your job description, and is it in an essential function? And second, is it an undue hardship to allow them to continue to work remotely? And sometimes there are legitimate reasons. I have one client who has very clear metrics showing that productivity dramatically declined when people started working remotely. They also are a tech company, and they have learned that the bandwidth in a home internet is not sufficient like their work internet. So they would get crashes and delays for people who are working remote. Those are the types of things that would give you an undue hardship defense, right? That would help you force that employee physically back to the office. But let's do a couple examples. So we have Jasmine, who worked from home during the pandemic, but now the company is returning everyone to the office. After hearing about the planned return to work, she calls to tell you that she's pregnant, is high risk, and her doctor's recommending against commuting to the office before giving birth. Okay. This one's a little easier because it's for a finite period of time, right? She's not asking to work remotely full-time, right, and permanently, but for this period of time when she's high risk. I think generally with any of these, you can push back on the doctor's notes that say remote work and say, I don't want the accommodation. I want to know what the restrictions are, because that really can arm you to have the broader discussion. For example, is it the fact that she's high risk or immunocompromised? Or what if it was the fact that she couldn't physically drive, right? I have some employers that have said, we'll send an Uber for you every day as an accommodation instead of remote work. Right? But you need to know what the restrictions are so you can think outside the box, right? If the person's immunocompromised, maybe instead of remote work, you can offer them a separate office or masks or hand sanitizer, all those things to protect them, from potential viruses, right? But you have to know what the restrictions are, not just the fact that it's remote work. All right, another one. Peyton's college friend, a roommate who just had a heart transplant, lives with him. She's on immunosuppressant medications that make her susceptible to COVID-19 and other illnesses. Peyton requests that he be permitted to continue working from home 5 days a week so as not to jeopardize her, right? This isn't, now remember, FEHA and the ADA, the accommodation statutes, those are for the accommodating the employee's disabilities, not a family member or a designated person of an employee. So technically, is there a duty here to accommodate? Right? The answer is everywhere outside of California, probably not, right? In California, maybe. There was a case that came down a couple years ago where it was a really sympathetic single dad who had to leave work early every day to give his son dialysis treatments. And the court said that there was a duty to accommodate an associational disability. In other words, he was associated with somebody with a disability. And therefore he needed accommodating. That was the first time we've ever seen that in the law anywhere. And we haven't seen it since, right? But it is case law now in the state of California. So there's potentially this associational accommodation obligation in California. I've seen a couple cases on this where people are alleging the associational accommodation was denied. So tread lightly, talk to your counsel. But generally in this situation, especially outside of California, there's no obligation here, right? Okay. One more. Reagan was diagnosed with a recurrence of cancer, is undergoing chemotherapy. She needs family support. Her home is located 2 hours from the office. During the pandemic, she worked remotely, but she has only been in the position for 1 year and could really benefit from some side-by-side learning. The company is returning all employees in her position back to the office. What do? Do we accommodate it? It's hard. This is a situation where, given that she's got cancer and going through chemotherapy and needs family support, you really want to accommodate, right? But you really also have to be uniform and consistent as well. So you're going to have to go through that undue hardship essential function analysis to decide, what you do here, and looking at what you're doing for other employees with accommodations as well. I've seen a couple employers get in trouble because they do accommodate the chemotherapy, but they don't accommodate the person who says, I'm immunocompromised and can't be around potential viruses, right? So it's tricky. You have to be careful. All right, I see that we are close to time, right, Jenny? So I'm going to speed up here. I want to mention one thing about commuting to work. I'm seeing a lot of notes where employees are saying they can't drive because of a disability and they need an accommodation as an accommodation employer to get them to work. Okay. Do you have an accommodation obligation to help an employee get to the job? There's a split in the courts depending on where you are. Some courts say absolutely not. They took the job knowing where it is. It's on them to get there. And some courts are saying, no, that could potentially be a necessary accommodation. So it kind of depends on where you are. I flag it so depending on, so that you can dig a little deeper if this issue arises for you. All right, lastly, mental health. 1 in 6 employees right now are struggling with mental health. This has escalated incredibly ever since the pandemic. There has been a real shift in the workplace. Everybody's probably seen and felt this. A lot of stress claims, a lot of kind of refusal or inability to work certain hours or different things. It's really kind of everywhere. And it's hitting the accommodation process. So I have a couple examples. One where this employee, Maddie, calls and tells you that she's fearful of returning to work and has anxiety being around people. She asks if she can work from home 100% of the time, right? This is no different than your analysis we talked about with the remote work, which is, is it an essential function? Is it an undue hardship for her position? Are there other accommodations, right? Can you give her additional breaks or some space, from other people, those types of things. All right, I'll give you one more and then I'll stop Jenny so we can answer any questions. Megan's routinely late for work. Her work becomes sloppy. You find her sleeping in her desk. You finally decide you need to discipline her, so you schedule a meeting. The morning of the meeting, Megan comes in frantic. She tells you she's been suffering from a medical condition and started taking medication to help her improve, but it makes her drowsy. We talked about this a little bit earlier. To the extent you've already disciplined, you don't have to rescind it, but you have to be careful going forward, right? Which is tricky because you also have to address the performance part of it. But you can't discipline for the symptoms, and that includes the symptoms stemming from medication that's addressing the disability. So here's another one that I'm getting a lot, unfortunately. So you go ahead and discipline her. It doesn't go well. In response, she first apologizes for being such a failure and then proceeds to talk about how she feels she can't do anything right and knows that she's worthless to the business. A few days later, a concerned coworker approaches you and says, Megan's talking about how she feels no one cares about her and she should just end it, right? There's a lot of these mental health situations right now. And I'm walking employers through putting the local police on notice, sitting down with Megan and talking through your EAP programs, making sure they have access to resources and doing what you can to address the mental health. And there's no easy way. I would say loop in your counsel early and make sure that you're thinking it through. They are challenging times. The other spin on this is I'm increasingly seeing that kind of violence not aimed at the self, but aimed at others, coworkers and stuff too, which we all see in the news is very delicate, very scary. So make sure that you're thinking kind of comprehensively and you're talking, using your resources and talking to your counsel, when these arise. All right. Okay, so we are right at the hour. I'm going to put up here my 10 practical takeaways and I will stay and answer questions. If you have them, which it looks like there are several. If I don't get to your question, I know that was a lot and I know we went really fast. So feel free to email me, feel free to call me as well. I'm happy to answer your questions and help you through your leave situations. All right.
Okay.
Go ahead, lay it on me.
All right, there's quite a few. So first of all, how long does the employer have to keep employee benefits while the employee is on leave and leave has expired and or doesn't return?
So you have to maintain them during the FMLA CFRA, the 12 weeks. And if the person is on PDL, you have to maintain them during PDL, right? You don't have to maintain during ADA or FEHA, only during FMLA CFRA and PDL.
Tiffany asked, the Pregnant Workers Fairness Act is administered by the EEOC and separate from any of the leave that we have discussed. Are you able to explain where that new law fits in terms of leave requirements?
Sure. It's actually not a leave statute. It's much like in California, our FEHA, where what it does is it basically says that any accommodations that you would give to, let's say, your disabled folks, you also have to give to your pregnant folks with disabilities, right? It more addresses the accommodation piece than
Hey,
it does
Michael, it's Beth from US Foods HR.
the leave.
How you doing?
Oh,
Let's mute that.
yeah. So it's more on the accommodation side. It says what we talked about on the accommodation side for pregnant folks, and that you have to accommodate folks with disabilities related to their pregnancies, whether it's helping them lift a certain amount of weight or have intermittent leave or to have time off for prenatal visits, whatever that looks like.
Sarah's asked this a few times. How do you handle pay for an exempt employee who can only work part-time due to medical restrictions?
Yeah, so there are so generally you never want to deduct a salary of an exempt employee because you risk kind of losing that exemption. There are certain exceptions, however, like for the example, the week of hire or the week of fire, you can do a partial payment of that salary. Another one is leave. You are allowed to deduct for leave increments. So if they're only working part-time, you can deduct the salary commensurate with that time.
I've been asked this a few times. Someone earlier asked about your 2-day leaves training. Danielle, can you share a link to that training?
Sure. I don't have a link at me, but I can tell you it's through BLR. I haven't done it in the last 6 months or so, but I know that they have it every quarter. It is 2 full days live, and they have them all throughout the state. So if you go to BLR and you put in, I would ask, if you're in California, ask for the California one, because they also do just a federal one. You want the California one, and it's 2 full days. I often teach it, but there's sometimes other people who teach it too.
And since sick leave is extending to 5 days, do we still need to provide a doctor's note for day 3 of sick leave?
Yeah, it's a good question. So there were a lot of questions the new statute answered and a lot that it didn't. I think over the next couple of weeks, we'll get more guidance from the state as employers try to get compliant. I think that you can still ask for a doctor's note as of day 4. But I wouldn't be surprised if once we get a bit more guidance, we're talking about you asking on day 6. I use day 4 because that's, it's used in the FMLA and the CFRA and the definition of serious health condition. And so day 4 is normally the day that I say you can ask for a doctor's note, but I'd keep watch as the new sick leave law is kind of rolled out.
To follow on, someone's asked, can we designate a leave policy if someone is out sick 4 days consecutively?
Meaning can you put them on leave?
Like designate a leave policy.
Not sure.
Someone's out sick
Maybe they
4
mean designate that leave, that absence is under leave. I don't know. It's going to depend more on the circumstance. I mean, you're going to want to, get a doctor's note, have them fill out leave paperwork, look at the eligibility requirements. I think we need to dig a little deeper. Into
they said you've answered the question. Thank you.
Okay, perfect.
Perfect.
And I do know that we're at 3:05. I'm going to stay on and answer more questions, but if you all have to leave to go to your next session, let me just say thank you very much for being here with me. I hope you found it helpful. And again, I hope to see you again, and don't hesitate to reach out if I didn't or don't answer your questions.
Yes. And I'll be sending out the presentation too after this for you, Danielle, to everyone.
Perfect.
Yeah. Okay, for whoever wants to stay on, I do believe they have 5 minutes till the next session starts. So if you want to, do you still want some questions? We've still got a fair few.
Yeah, I'm happy to give it another 5 minutes or so. Sure.
Okay, so someone's asked, Catherine's asked, can you please give us a quick summary of the new reproductive leave?
Oh, okay, it's unpaid, and it's kind of evolving a little bit, but essentially what it does is it clarifies that reproductive loss is a reason for the leave, right? So when you're looking at your CFRA in terms of the reasonings for the leave, and now we know what the law clarifies, that it includes a reproductive loss is what that is, or miscarriage, essentially.
Mm-hmm. Christine, I'm not sure if she's still here, but she was asking, would or should we get a doctor's note regarding the postpartum depression, or just take the employee's word for it?
I would get a doctor's note. The only time I wouldn't get a doctor's note is for the recovery period post-birth, that 6 to 8 weeks. That I think you take the employee's word for it. But anything beyond that, like the postpartum or the high-risk pregnancy before, you're within your rights to get a doctor's note. And I would, because that doctor's note is not just going to say that it's medically necessary, it's also going to give you an end date, right? It's going to tell you the duration of the leave, and you need that in order to manage the leave and in order to manage your staffing, operationally.
Are you good with time? Yes. I've got 3 minutes. Okay. So this is an example. An employee provides a doctor's note that indicates the employee can't work at a conveyor because it makes her dizzy. What else should this note indicate, or is this sufficient for an employee to evaluate and make a decision as to being able to accommodate?
Yeah, good question. The other thing, the thing that the note is missing is the duration. How long? Remember, an indefinite accommodation is not reasonable under the law. If you hired her to work at that conveyor belt, at some point she's going to have to work at that conveyor belt again. It's reasonable for you to transfer her or to alter her duties temporarily, but you have to know that duration. So I would send her back to find out how long she's going to need that accommodation, because maybe it's a week, right? And you can easily move her for a week, or maybe it's 6 months, right? And then you have to look at different options. But that's the piece that I would always make sure that you get. It's not just the restrictions, but the duration.
Sombra was asking, please restate the number of sick days an employee needs to be out before we can request a medical note. So,
Yeah. That's what we were talking about before. It's a bit in influx because of the new law. Traditionally, until this new law, it's been you ask on day 4, right? You don't ask in those first 3 days because the retaliation part of the law. In other words, if you ask for a doctor's note for those sick days, it may deter people from taking them, which is seen as retaliatory, right? And I think that it's likely that this new law is going to extend that through the 5. But I don't know that for sure right now.
we have 1 minute remaining. Are you good for one more, Danielle? And maybe the rest,
Sure.
if everyone else can maybe email you their questions directly. So one is, if the employee refuses to accept a reasonable accommodation, what are some of the next steps that the employee can do in terms of managing?
Yeah, it's kind of like the question where the person
Situation.
never gives the leave paperwork back, right? You want to be really clear that the breakdown and the interactive process is on the employee, right? You have lots of emails saying, you know, we're willing to work with you, we're willing to meet with you, we're willing to talk accommodation, and you want it clear in writing that it's their refusal, the process is breaking down because of them. And when that happens, then I think that you have a lot of options where you can potentially part ways, right? Because the employee really isn't giving you much of a choice, but you want to be clear that in the documentation that it's their fault, not yours.
Okay, I believe we are at time. There are a few outstanding questions. I will ask maybe that everyone does reach out to you directly, Danielle.
Yeah, of course.
Okay. And you've got your contact details on there. I really want to thank you, Danielle, for such an interactive and interesting and very important topic. So thank you.
My pleasure. Thanks for having me. Thank you, everybody.
Thank you, everyone.